Hello, welcome back to Lifestyle with Nafula. I'm Nafula Lubia, and this is episode 2 of our new series, Why Knowing Where to Start Matters, the multiple doors of access to justice in Kenya. Today we are talking about mediation, how it works in Kenya, and when it is used. So in the previous episode, we looked at why Kenya's justice system provides more than one pathway for resolving disputes. One of the most commonly suggested pathway is mediation. Mediation is a process in which parties attempt to resolve a dispute with the assistance of a neutral third party known as a mediator. The mediator facilitates discussions, helps clarify issues, and supports negotiations, but does not make a decision for the parties. Let me repeat that. The mediator facilitates discussions, helps to clarify issues, supports the negotiations, but does not make a decision for the parties. So what would happen a lot of times when there's a dispute between parties, sometimes the temperatures are hot, the mediator helps to calm down the people, the mediator sets the ground rules for the people to talk. Sometimes one party can air their grievances in a way that offends the other party. The mediator helps to tone down the language and to help each party be in a position to understand the other party. But at the end of the day, the decision is made by the parties and not by the mediator. So the control over the outcome of the mediation remains with the parties. In Kenya, mediation appears in two main forms. We have private mediation, where parties may enter into mediation voluntarily, often with the advice or assistance of their advocates. And the second one is court-annexed mediation, where the court refers existing matters to mediation while retaining supervisory control over the proceedings. So the use of mediation usually reflects the reality of certain disputes, the reality that certain disputes are better resolved through agreement rather than adjudication. Disputes involving family, especially succession matters, disputes involving neighbors, because you still have, at the end of the day, have to live together, disputes involving business partners or long-term relationships often require solutions that a court judgment does not easily provide, and some resolutions, such as an apology, are not provided at all through the formal justice system. But mediation offers several practical advantages. Mediation can be faster, it is less costly, it is more flexible than litigation, it allows parties to speak directly to one another and to reach outcomes tailored to their circumstances, and proceedings in mediation are confidential and relationships are preserved rather than strained any further. It's very beautiful that proceedings in mediation are confidential, and therefore, as opposed to the normal court proceedings, which are public records. And therefore, you can say it's a divorce, it's a children's matter, or it's a business matter where there are trade secrets, patents, and all these other forms of intellectual property or private matters that you prefer to keep private for the integrity of your businesses and for the integrity of products and services, then mediation offers the confidentiality aspect. And then the fact that it is possible to maintain relationships even after the dispute has been resolved. And where the dispute is not resolved, mediation is still beautiful, because at least by the end of the day at the mediation table, parties iron out the issues, and it is now clear to each of the parties what they disagree on, and therefore it even makes the court process faster when the parties know, when the parties have narrowed down their issues to what exactly they disagree on, because now the courts can factor on that which they disagree on, and not all the other factors that they agree on. But mediation is not universally appropriate. There are situations that involve serious power imbalances, coercion, violence, or urgent protective relief that may require immediate judicial interventions. The courts are attentive to these limitations when determining whether mediation is suitable. So, for instance, in a matter where it involves a child or a person who's considered to have, say, mental disability, the courts will be very reluctant to send that matter to mediation. Matters touching on sexual offenses cannot be sent to mediation because of the seriousness of the matter. Rape cases will not be sent to mediation. Some courts may send them to mediation, but ideally they are not sent to mediation. So mediation is not suitable for all types of situations, and sometimes domestic violence. Sometimes someone has been beaten, very badly beaten. They've come to court for a criminal matter, and someone suggests wanataka kwenda nyumbani waongee. Sometimes based on the severity of the matter, the court may be reluctant to refer the matter to mediation. Yeah. So a common concern, like I said, a common concern arises when a matter is referred to mediation after litigation has begun. Some litigants worry that agreeing to mediation means surrendering their right to return to court. In practice, mediation operates within the judicial process rather than outside it. So where mediation does not result in an agreement, as I've stated, the matter proceeds through the court system in the usual way. However, the process is fastened. Why? Because the mediation matters that have gone through mediation are given one priority. And secondly, you have narrowed down the issues, and therefore the court can now focus more on the issues rather than the side issues. So mediation therefore functions as one recognized method of resolving disputes rather than a substitute for justice. One thing I should mention that I did not mention about private mediation is that when you have private mediation, usually when you have like private mediation, it is not binding. However, when you register your private mediation agreement and you drop that agreement in court, it becomes an enforceable agreement. If one party fails to comply with the terms of that agreement, then the other party can extract a court order and enforce that agreement. So when you conduct private mediation, it is important that you also lodge that private agreement with the mediation registry closest to you, so as to protect its enforceability and your legal rights. Having said that, in the next episode, we will examine alternative justice systems which operate in a different space but are equally recognized within Kenya's constitutional framework. So if you like what you have heard, if you have benefited from what you have heard, if you'd like to hear more, I would like to engage with you. Please like, share, and subscribe to my YouTube channel. There is more to come. Until next time, bye-bye.